All right, y'all, man. So I'm back with another video. So y'all already know we're still waiting on the AG to make a ruling on the records for the DPS and the district attorney's office. Mind you, I did that like early to mid February, and it said it'll probably take like 60 days. Let's just say 60 days. So I should be hearing something back by mid April, and whatever it is, I'm sharing it with y'all. And that's just what it is. But I do remember when I was what was this? What was this? This was when I appealed. So I did my appeal, boom. I remember reading paperwork and I remember mentioning something about blood. Mind you, this has been on my mind since 2017, because that's when I did the appeal, 2017. And that's when I read back when they came back with the decision or whatever. And I remember them mentioning something about blood. And I never, like I say, I really couldn't even do anything. So I was just holding on to that the whole time. And as we moved further along, it popped back up in my head. And I was like, I remember them mentioning something about blood, and I thought they said my blood was under the girl was under the girl nails. I just really couldn't exactly remember because I haven't gone back to look at this stuff since like 2017, 2018. You know what I mean? Because it was just like, okay, I'm on probation now. I gotta knock this out. I got bigger fish to fry. So what I did, I remember I asked ChatGPT about the whole blood thing, right? And ChatGPT was like, well, when you find, where they were talking about blood, pull it out, upload it to me, and I'll help you. Uh, damn, my brain for it. I'll help you understand what's going on, right? I better clarify for you. So it's like cool. Then I also, with that being with that too, I also went on another rabbit hole, and I actually found out what the DNA analyst actually said at the trial. So I went through the trial records. I don't know what made me do that, but I went through the trial records and found out what he said too. So that's another video. But let's go ahead. Excuse me. Let's go ahead and get into what he said about the blood when I uploaded those those particular pages into ChatGPT. So it says, now that you uploaded this is exactly what the problem is in Jonathan's case. It says, let me show you what the state quietly admitted right here, because most people, including jurors, don't catch this, or juries. It says, this sentence changed everything. From your first screenshot, initially, appellant was excluded, but upon reinterpretation of the previously gathered data pursuant to changes in the DPS interpretation guidelines and in the FBI database used to calculate statistics, DPS issued a subsequent report. That means they did not run a new test, DNA test. They did not collect a new sample. They did not extract new DNA. They went back and looked at the same exact raw data under the new interpretation rules. So, like I said, man, I'm not here to feel sorry for myself. You know what I mean? I'm just here to push this out to y'all so y'all can actually see. At the same time, my job is to do my own investigation on my own case. Do with my lawyer, in my opinion, what I feel like she couldn't do or what she didn't do. She didn't ask questions, in my opinion, because it shouldn't even got this far. But it's besides the point. So then it says, in plain English, the DNA did not change, the science did not change, the rules for reading the DNA changed. So before, Jonathan excluded; after, Jonathan cannot be excluded. And that's the thing too, bro. That's the thing when you sitting there, and I'm remembering this. You hearing them say he couldn't be excluded, and you talking to the jurors, right? You got 12 jurors who don't know anything about the law. So when you talking about he can't be excluded, they automatically thinking that you included, not knowing, not even knowing that this even happened, not even knowing the reinterpretation, not knowing that it was excluded at first. That all of a sudden they reinterpret. You know what I'm saying? They didn't know any of this. That's what's crazy, dog. And then you find this out years later. This is what happened. It's all crazy. But like I said, these jurors, they don't know anything about the law. So you can fish them a bone and tell them it's out of bait. And you know what I'm saying? And they'll go for it. I try to be funny. But I'm just trying to get y'all to understand, like, it's like a kid. You know what I mean? Like, they don't know anything. So you can feed them anything, and then they're going to eat it up as if they know exactly what's going on. So it says in plain English, the DNA didn't change, the science didn't change, the rules for reading the DNA changed. It says so before, Jonathan excluded, after. Jonathan cannot be excluded. It's just crazy. So it says same samples, same peaks, same electrophorograms, different interpretation policy. And I remember, like, I was thinking, like, when my lawyer told me that, I was thinking to myself, like, how she ain't, I'm thinking, but everything moving so fast, I'm kind of like, how she ain't questioning how they go from my DNA was on the girl to weeks later, then all of a sudden my DNA was on the girl nails. You know what I mean? Like, how did that change? Like, why didn't she question it? That was my thing, but I couldn't make those words out because I'm looking at my lawyer. I'm looking at my lawyer as my, my person to, she knows this. She knows law. Like, I don't know anything about this. Like, why didn't she question that? So then it says, this is called post hoc reinterpretation. It says, and this is one of the biggest litigation battles in forensic science nationwide because analysts can go from exclusion to basically inclusion without ever touching the evidence again, just by changing thresholds and statistical models. And it get worse. Fingernails. Same paragraph says, many of the items analyzed did not contain a sample sufficient for comparison. That means originally that wasn't enough DNA to compare anyone. But later, appellant couldn't be excluded as a contributor to the DNA mixture found on the complainant's fingernails. So originally, not enough DNA to compare. Later, now we can compare and he can't be excluded. Again, no new test, just reinterpretation. Meanwhile, the most important DNA in the case from your next screenshot, mind you, I'm loading that shit in like boy, you don't understand. It says appellant was affirmatively and conclusively excluded from being a contributor to the male DNA found in the complainant's panties. Says that is YSTR male DNA from the crotch area collected hours after the assault. Victim said no sexual contact that week. Jonathan excluded. Meaning there is unknown male DNA from seminal-related material or blood, acid phosphate, weak positive, and it is not Jonathan. You know what I mean? I'm just here to bring this to y'all. Talk about my case, man. I'm here to shed light and do all I can do for myself and my case. You know, it's a lot, dog. But hey, man, we still alive and we breathe, and then we able to keep contesting this shit. You know what I mean? So then it says, and even Benson noted from your last screenshot, Mr. Benson noted that he did detect blood inside complainant panties. Blood equals cellular DNA source, not just touch DNA. So when the prosecutor argued it's just touch DNA anyways, well, I remember that. I remember sitting there and hearing her say that. But when you on trial, you can't say nothing, bro. They make you sit there like you stupid. You just be sitting there. Like, it's weird, bro. It's like, I can't, hey man, you can't do none of that. Nothing. You just sit there and your lawyer talking for you. And it says, so when the prosecutor argued it's just touch DNA anyways, that directly conflicts with blood detection, enzyme test, acid phosphate. And it's a lot of contradiction and conflicting going on. But y'all see, as we keep going, you will keep. That's why May 14th, let's just say May. Let's say May 2015, those lab reports are very important. So that's what we're really waiting on to get. That's kind of, I don't even really care about the DAs, all that stuff. I just want it because I can get it. You know what I'm saying? If I can get it, I want it. Why not? You know what I mean? It's like, play the game. Like, they get what they want. Well, I can't get what I want either, right? Just because you got the power to do so. It says, so to answer your question directly, because this is what I asked ChatGPT. If my lawyer said my DNA wasn't found, and later it said low-level DNA, how did my DNA appear under the nail? Based on what you just uploaded, it didn't appear. They reinterpreted low-level mixture and changing DPS guidelines and statistical database calculations, which allowed them to now compare you where before they couldn't. I still don't even know what that means, man. Like, I'm trying to understand as I go. Then it says, this is why getting the May 14th original reports matters. And that's what we banking on. It says you now have hold on. me slow it down. You now have documentation that that was an initial exclusion followed by a reinterpretation without new testing. So it's the May 14, 2015 report is where the original conclusion lives. That report is critical to show what DPS said before reinterpretation. So that's why May 14, 2015 is so important. We got to get to the bottom of it. We got to figure this out. And I'm enjoying the journey, dog. Like, I'm a fighter. And, you know, nothing makes me more happier than to strap them up and, you know, be in the paint and they see you, but they can't stop you. You know what I mean? Like, that shit feels so good to know that you going back and forth with these people and there's nothing they can do about it. They have to sit there and go back and forth with you. It's like, damn, they rose from the dead. You know what I mean? But I don't want to keep y'all. I don't want to hold y'all. You know what I mean? So go ahead, for real. Like, subscribe, share, and be ready for the next video.